Hello, thank you, and welcome to this session of class of recording. I'm so privileged. I know it has taken a while for me to do a live stream on YouTube. I've done it, but I've been doing on Facebook. And so what I want us to learn today is you'll excuse me for my lighting, although I will be sharing my screen, so probably you'll not be seeing me. There is something that I want us to learn today at the Academy. This is on tax appeals. We have cases which go for tax appeals at the Kenya Revenue Authority, which I think is important that we learn from. Normally what happens there, you can be investigated by KRA. They can come to your business or even to you individually. And mostly this is out of, sometimes it's out of them getting a clue or a whistleblower that probably you are not paying your taxes. And then they will come and do their own assessment and give you, give you their own assessment of what you're supposed to pay. And so I want us to review a case which went to the tribunal. So normally what happens if you feel that what the assessment that they have given you is maybe too high or is not the right position, then you are free to go to make an appeal at the tax tribunal. But before you do that, you can always engage them. And in this case, you don't engage them directly if you want to have a proper assessment. You engage, first of all, a tax agent. A tax agent can be an audit firm. There are audit firms that do tax consultancies, or maybe a tax consultant, or a lawyer, a law company, a law firm that does tax consultancy. And so I want us to look at what happened in a particular case here that I'm going to share with us. And then we are going to see what happened and if you can learn something from there. So I'm sharing my screen here. This is a case of the Nekey, I'll read it the way it is, Suppliers Limited, being the appellant. They're the ones who went to the the tax appeals tribunal. They went to the tribunal, probably, not really probably, but actually out of an assessment that they didn't agree with. And so you will see that the Commissioner Investigations and Enforcement, that is actually a department in KRA that does investigations and enforcement, was the respondent. So I will, for purposes of argument, we'll just say KRA. And we have there the background. I will try to help us understand this, this judgment. And this is a public document. That's why I have no, we're using it for purposes of learning. It's not meant to paint the company in bad light. And actually there is a good example of, as you're going to see, of how they were given a very huge assessment, which went down from over 200 million to about 13 million. So you will be learning something. Let us see the background of this judgment. The appellant, that is the company, is a resident company in Kenya. It's a company resident in Kenya, incorporated in the year 2013, dealing with supply of construction materials, among other businesses. The respondent is a principal officer appointed under the provision of Section 13 of the Kenya Revenue Authority Act, Cap 496, the laws of Kenya, with the mandate to administer and enforce various tax statutes, among them Income Tax and VAT Act. The respondent investigated the appellant company together with its directors and related companies to determine the amount of tax payable, if any, by the appellant. So the respondent, upon investigation and for the further action, issued a preservatory orders by the notice dated 5th December 2017, directed to Diamond Trust Bank under Section 43, subsection 2 of Tax Procedures Act, to preserve for 10 days the account of one of the directors, of the appellant, and 3 other accounts of its related companies. So you find that Kenya Revenue Authority normally, if they have any reason to believe that there is some tax obligations that have not been paid, they can always write to your bank and ask them to kind of stop any operations on your account. Okay, that's what they did. Later, on 29th November 2018, the respondent issued a letter to the appellant requesting for a meeting to discuss your tax matters. On 29th March, that's almost 6 months later, the respondent issued a notice to the appellant referred to as investigation findings, demanding an amount of 209,947,278 shillings in both income and value-added tax. Now, you find that, as we are going to see, when KRA does its investigations and raises such an amount, and as we are going to see that the amount came down, probably in their estimation, the client, the company, the appellant, was not cooperative. And so they did their assessment and just sent. And so that normally, sometimes, this is my own argument, probably they want to throw the spanner into the works so that you come out and then discuss with them. So the notice referred to several meetings and communications between the parties before reaching the conclusion to the demand for payment of taxes. The notice related to taxes between 2015 to 2017 tax period. Other engagements and exchange of documents which were requested by the respondent went on. At some point, the appellant requested more time to avail tax documents, citing unavailability of documents dating back to 2015. Both parties seemingly indulged one another, both citing complications and challenges faced during the height of COVID-19 pandemic. The engagement yielded results where eventually a tax assessment of shillings 106,324,442 was issued by the respondent on 18th August 2020, down from the initial 209,947,278. So we are seeing that after a back and forth, they have now agreed and revised the assessment from 209 million to 106 million. That is, it has gone down by half. Yeah. Now, prior to that, as you're going to see also, the appellant had paid 1,024,838 shillings, being undisputed tax. You normally have tax that now, this one I should pay. Then they had paid 1 million. The payment slip copy is annexed to the appellant appeal documents and is dated 21st August 2020. Now, why did what is the essence of the appeal? So this is the reason, as you can see in the note 12, when the respondent issued the assessment for the sum of 106 million, the appellant was dissatisfied. So you find the appellant was still dissatisfied with the assessment and objected to the same by lodging an objection dated 10th April 2021. The objection was acknowledged by the respondent. So, as I had indicated earlier, before you lodge an appeal, at the tribunal, you always try to negotiate, try to do a reassessment, try to make some effort to have the amount reduced. And we can see that already now they are at 106 from 106 million up from 209 million. So on 21st April 2021, the respondent requested the appellant to supply relevant documents, which the respondent has acknowledged receipt in his pleadings. The last documents were received on 21st May 2021 and 30th July 2021. On the 20th September 2021, the respondent issued his objection decision, in which the respondent confirmed the taxes as follows. So, having looked at the documents, you see they have looked at the documents. We've been given documents on 26th May and 30th July. They have been given documents. So he's saying that on 20th, yes, on 20th, that is after about 1.5 months, the respondent, that is Kerry, issued subjection decision in which the respondent confirmed the taxes as follows. So you see, after they looked at the documents, they now revised their assessment, now be as listed here, where the principal amount is 13.3 million, the penalties are 2.6, and the interest is 3.4, amounting to 19.4 million. I want you to see that I want to really appreciate that the company here, the appellant, was very thorough in having reduced this amount from 106 million to 19 million now, actually big to 13 million, because the rest are penalties and interest. They have done a good work. And I think you need to know that that was the work either of a very smart accountant in the firm, in that company, or a tax agent that probably the company had involved. Because naturally, what would happen if you were not well guided? You would run to KRA and try to negotiate on how to pay the 209 million and run like headless chicken, trying to convey, to ask them to help you. In which case, probably you would end up paying half the amount as was already projected here. But they still went further and provided supporting documents and were able to come up to 13.3 million. So it is in regard to the objection decision that the appellant proceeded to lodge his appeal to this tribunal on the 19th October 2021. So you are seeing that there has been a back and forth from the time that they got 209 million, then they objected, then it went to 106, they still objected, then it went to 13, which is now 19 because of interest and penalties, they still objected. So as they are going to the appeals tribunal, they have already brought the amount substantially down, actually to about 10%, actually less than 10%, because 10% of 209 million would be about 20.9 million. Yeah, but now they are at 19. So this is less than 10% of what was initially expected of them. So that is why they have gone to the appeals tribunal, which sits at the Kenya Revenue Authority. Is it works for Kenya Revenue Authority. I mean, there are judges there, there are magistrates there. I mean, they are the ones who makes these rulings. Let us see the appeal. In its memorandum of appeal dated 19th, as we have seen it, they went to the tribunal on 19th. The appellant raised the following grounds of appeal. Number one, that the respondent, that is Kenya Revenue Authority, the investigations department, erred, they were in error in fact and in law by failing to consider expenses wholly and exclusively incurred in the production of the income as required under Section 15 of the Income Tax Act. That was one ground. Number two was that is B, the respondent erred in fact and law in attributing all income in the bank account to an individual, Mr. Jing Deng, as income of the appellant. And then we have the appellant erred in fact in arriving at the conclusion that the deposit made in the bank accounts of Jing Deng were diverted sales and brought the same to tax charge. The respondent erred in fact by treating the deposits in Jing Deng's bank accounts as the appellant's invertible sales. The respondent erred in fact and in law in rejecting input VAT claims by the appellant. The respondent erred in fact and in law by issuing tax assessment for the financial year 2015 beyond the statutory time limit prescribed contrary to Section 31, subsection 4 of the Tax Procedure Act. The respondent erred in fact and in law in imposing tax shortfall penalty under Section 84 of the Tax Procedure Act in contravention of this section or Section 89, subsection 3 of the Tax Procedure Act and Article 47 of the Constitution. That the respondent failed in fact and in law to appreciate allowable deductions as provided under the Income Tax Act. The inordinate delay by the respondent to issue assessments and objection in this matter from 2017 is a denial and or infringement on the appellant's rights for fair administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair as guaranteed by Article 47 sub-article 1 and 2 of the Constitution. Now, those were the grounds that the appeal was founded on. Those are the grounds that the appellant brought to court, to the tribunal, that is. So the appellant's case was that the appellant's case is premised on the hereunder documents and proceedings before the tribunal. You can see there were the statement of facts dated and filed on 19th October, together with the documents there too, the appellant's written submissions. So they had two documents, sets of documents. The appellant has, through its written submission, identified the following three issues as falling for determination by the tribunal, whether the respondent failed to appreciate allowed deductions. So you can read it for yourself. I mean, this is a public document. Then I want to see and also to advise that many times when you go to this tribunal, many times they agree with the investigator. They agree with KRA. And so my advice would be that before you go to the tribunal, exhaust all avenues that are available and try to engage a tax agent so that the tax agent can help you with documentation and negotiating with the Kenya Revenue Authority, trying to support the documentation, your claims as much as possible. Because a tax agent will be able to know which documents are required, how to apply the Income Tax Act, whether it is the VAT Act, the deadlines, the penalties, and they know what to answer at this particular time. And so many times, as you will be listening to the classes or with regard to tax, you'll realize that the judgments are most of the times in favor of the Kenya Revenue Authority. And so, for instance, if they had come here when the amount was still 109 million, most likely you'd find that they would lose the case. And so I'm saying that so that you be aware that, in summary, what was finally decided, the case was whether, which were brought for determination, whether the respondent failed to appreciate allowable deductions as provided for under the Income Tax Act. You know, there are normally allowable deductions, which you cannot say that if I have sold 1 million, then 1 million is taxable. I mean, under income tax, I have to remove my expenses, and so that I only pay taxes on the profit. So there are allowable deductions as provided for under the Income Tax Act. So that was brought for determination. Then there was also whether the income in the bank account of an individual can amount to vertible income of the appellant. Yeah. So they were, you see, this was a director, Jing Deng. So they had felt that there was a diversion of sales. So that was also brought for discussion, I mean, for determination, whether tax assessment done in the year 2021 for the year 2015 and objection decision issued 5 months after the appellant raised its objection contravenes the Tax Procedure Act. So those are some of the areas that were brought. Those are their issues. Then the respondents also had their case. The respondent's case is premised on the respondent's statement of fact dated the 18th November, together with documents attached. So they also had a case. Let me just see some of it. The respondent commenced investigation in the tax affairs of the appellant in 2018, following intelligence reports that the appellant was under declaring revenue and overstating its purchases. So that's very important, that sometimes the intelligence reports could be emanating from maybe your employees. I'm not saying that now you hate employees, but it could be someone who knows your operations. And so, like in this case, there was an intelligence report that they were under declaring revenues and overstating purchases. Then the investigation covered the period 2015 to 2017 with the main objective of establishing the amount of income not declared and possible taxes to be collected. So those were the basis. I think that is very important. So what else are they saying? That following engagement between the parties, the appellant was issued with a tax assessment of 106. Now they are not talking about 200 million because now it is after they have now engaged. Then they came to 106. The respondent requested for supporting documentation for the appellant for purposes of validation of the notice of objection. That the appellant provide the relevant documents, and upon consideration, the respondent issued its objection on 20th September 2021, confirming principal taxes of 13.3 million in respect to corporation taxes and VAT. And so this is the final one. This was the final objection. We call it what? The relevant documents on May 26, issued its objection, the decision on 20th September. So it came down to 13 million, as we had already said. Now, let us see how it was held. The respondent's prayers was that the tribunal upholds the assessment as it is, that is the 13 million plus interest plus penalties coming to 19 million, and dismiss the appeal with costs. The issue for determination before the tribunal, now the tribunal now sits and also considers both sides, and now filters and says now the issues for determination are these: whether the respondent issued the objection decision within the statutory timeline, whether the tax assessment for the tax 2015 was issued beyond or outside the statutory time limit, contrary to section 31, subsection 4 of TPA, the Tax Procedure Act, that is, whether the respondent rightly issued penalty for tax shortfall under section 84 of the Tax Procedure Act, whether the applicant is liable for the confirmed taxes. So the analysis and determination, the tribunal, having identified the issues falling for its determination, proceeded to separately analyze the same as follows. It is not in dispute that the appellant and the respondent robustly engaged, and that is the reason why the original assessment that was for a sum of 209,974,278 shillings came down to 106,324,442. Then upon lodging and determination of the objection, it was subsequently adjusted to a sum of Kenya shillings 19.4 million, being principal taxes together with penalties and interest. It is not lost to the tribunal that the appellant also paid a Kenya shillings 1,024,838 shillings, being the undisputed taxes. So whether the respondent issued the objection decision within statutory time, then they pass their decision. They say that the appellant pleaded for a determination as to whether the inordinate delay by this issue was relating to the rights, and they say that we will not dwell on Article 47 of the Constitution, as that belongs to the High Court in the enforcement of rights. So they have skipped that one. They are saying that's not within their mandate, or jurisdiction. It suffices to say that according to the engagement between the appellant and the respondent, it was clear that the appellant was accorded the right procedure under the Tax Procedure Act. The notice of objection was lodged by the appellant on 10th April 2021, and an objection decision was issued on 20th September 2021. The relevant statutory provision on issuing objection decision is section 51, subsection 11 of the Tax Procedure Act, which reads as listed. And so, in a way, they are saying that everything was in order in terms of the timeline with which decisions within statutory timeline. So the tribunal is agreeing that yes, it was within the timeline. And so it's like that plea by the appellant is not off. And then we have whether the tax assessment for the tax year 2015 was issued outside beyond the statutory time limit, contrary to section 31, subsection 4 of the Tax Procedure Act. It's also argued there. The relevant statutory provision allowing the Commission to amend self-declared return is section 31, subsection 4, which reads as stated. But what did they decide? So the tribunal so to that extent, the notice of additional tax assessment issued on 18 was well within statutory time limit. Yeah, so you find that as we are seeing already, the tribunal is agreeing in all the charges, all the issues brought before them. They're agreeing with the investigator, that is KRA. And so what is the final? In the circumstance, the objection decision as relates to the confirmed taxes stands uncontroverted as from the general fact and submission made on the part of the appellant. Final decision, the upshot of the foregoing is that the appeal partly succeeds and the tribunal proceeds to accordingly make the following orders. The appeal be and is hereby allowed in part as relates to the imposed penalty under section 84, subsection 1A of the Tax Procedure Act. That is not payable at all. Now, that is very important. I want to take you there. What the court is, the tribunal is saying is that by the time they were issuing this, their determination, objection notice, they accompanied it together with the taxes, with the penalties and interest. And so the appeal, the tribunal is saying that that should not have happened. Yeah. Then you see, I want us to read that, because that is very important. Yeah. Then I've seen it. The appellant has not provided any direct evidence to demonstrate that the confirmed. Let me see. There is okay. So it's important to note that this section 84 subsection 1, the appellant insists that the omission in the filing of proper returns, the period of investigation, were inadvertent and were not in any manner calculated to occasion in any tax evasion or direct benefit to the appellant. In the objection proceedings, the respondent did not touch on anything regarding this issue under section 84, except in tables 3.4, 3, 4, and 5 earlier stated, to include penalty on shortfall for the year 2015, years of 2015 and 2017. Seemingly, there was no taxes due for 2016 from those tables. And so this is what is important, where the tribunal agreed with the appellant. It says a perusal of the notice of tax assessment issued on 18th March 2021 clearly manifests that there was no demand made for any penalty imposed on the principal taxes assessed and found due and payable. The penalty was imposed at the instance of the issuance of the objection decision, and to that extent, that is found to be irregular. What they are saying is that before you demand for penalties, you must have given the person demand notice. And so they are saying that there was no demand made for any penalty imposed on the principal taxes he assessed and found due and payable. So that is to find now in the final decision, they are saying that the appeal be and is hereby allowed in part as relates to imposed penalty under section 84 is not payable at all. So the penalties are not payable. That's what it's saying. The objection decision issued on 20th September for the principal amount of 13.3 million plus interest, he and is hereby partly upheld. Now you realize that now the penalty is not being talked about. They're now talking of the principal and the interest. The appellant is entitled to a tax credit of a sum of 1,024,838 arising from the undisputed taxes subsequently paid on its part. The party to bear its own costs. So that is it is so ordered and dated and delivered at Nairobi on the 9th day of September 2022. So you find that the chairman of the tribunal was Eric N. Wafula. We have member Rodney Oluoch, John Kinyua, member, Habon Farah, member, Edwin Cheluget, member. So that is a clear decision that is made. And so the applicant will only pay, let us see that table again. The appellant will now pay 13.3 million and then the interest and will not pay the penalty. I just want us to look at that table again, and then that would be over. This is the table that I'm talking about. There is 13.3 million. Then there is the interest of 3.4. I don't know whether this interest is after including penalty and principal, but what we are saying is that the interest on VAT of the principal will be calculated, and then the interest on the income tax calculated, and so they will pay less than 19 million. So thank you very much. I hope you have learned something, and you can subscribe to this channel if you are meeting us for the first time. We will be doing analysis of these cases, the ones that we feel interests you and can also help you with if you have any case. So you can like, subscribe, share, comment, and ask any question with regard to taxes. And I hope you will be properly guided. So thank you.